Hello, welcome everybody. And my name is Alison Pello, and here we are doing our episode 11 of our live streams. These are a technical challenge, these live streams, I must say. This is our second attempt today. So, the first attempt, we're not entirely sure what happened because it was working on YouTube and I think it was working on Facebook, but it wasn't working on LinkedIn for whatever reason. So what we're doing now is we're trying it for a second time today. And today we've got with us Marie, who's an employment lawyer. She's going to introduce herself in a moment. But the reason we wanted to do this one today is about restrictive covenants, is that the world of recruitment has gone bananas. And everybody's telling me that from lots of different places. So they're calling it the great resignation. So people post-COVID are feeling like they want a big change. They maybe have had challenging situations, maybe don't want to work at home, maybe do want to work at home, whatever it might be. And so they're deciding to take a different route, maybe going for a new job. Similarly, employers are looking to take on new people, maybe had organisational reshuffles, downscaling, whatever it might be. So they are, looking at maybe creating some new contracts. So this world of contracts has never been my speciality, and that's why we've got Marie. So I'm going to let Marie tell you about herself and her organisation, and then tell you, we've got some slides to go through about restrictive covenants. Over to you, Marie.
Thanks, Alison. It's a bit like Groundhog Day. So for those of you who don't know me, my name's Marie Walsh. I'm an employment lawyer. I've been practicing for 20 years, and I've got my own business called Concilia Legal, based in Leeds, London, and Harrogate. So I've got a small team, and we advise employees and employers. And as Alison said, over the last sort of 3 to 4 months, what we've seen is less grievances being raised and more people voting with their feet. In other words, moving on, life's too short. Let's just leave environments that we're not happy in. And employers are looking to protect their businesses, whilst employees are looking for advice on what they can and can't do. And to be fair, most employees are looking to do things the right way. And employers are looking to just do things the right way. And the main question we get is about restrictive covenants. And firstly, I think it's fair to say that obviously there are restrictions when an employee is in employment, and there are implied duties and there are contractual terms normally. And we don't tend to get many inquiries about that. There's not many moonlighting cases at the moment. But in terms of what can happen when somebody leaves, that can be quite gritty, and litigation in that area is quite expensive. So we thought we'd just do a quick sort of highlights today. We've not got too long, about half an hour maximum. Probably less with it if there are any questions, but what are the courts looking at, and what's the position? So just looking at restrictive covenants then, if you do have any questions, just feel free to pop them in the chat and we can address them as we go or at the end. It's really fair to say that restrictive covenants are not popular. So the view of the courts towards restrictions, particularly on employees, are that the first view is that they're void and contrary to public policy, unless they are reasonable and there to protect legitimate business interests. So it's not the case that as an employer, you're able to just impose restrictions to not think it through. What you've got to identify is your legitimate business interest that you're trying to protect, and what kind of restriction you need to protect that interest, and how reasonable you can make it. So in terms of the legitimate business interests, so by way of example, it might be your client base or it might be customer contacts. Those are the most common business interests. There are also other business interests, of course, like intellectual property, particularly in the world of digital. There might be other IP elements that you want to protect. But in terms of restraints, you've got to think about reasonableness in terms of duration, and by that I mean time. So how long do you need to restrict somebody after they leave employment legitimately to protect that business interest? And it's got to be no longer than is reasonably necessary. And also we look at geography in those terms as well. So things like Are you preventing somebody from working or seeking to prevent somebody from working in a competitive industry, for example? Where are you preventing them from working, and is that reasonable in the circumstances?
Well, that's a good point, because at the moment now, with everything being virtual, talk to us about that and the impact of the different ways of working.
Yeah, I mean, that has become now one of the issues. So I've got lots of employers saying to me, well, I need a countrywide restraint, so you can't work, for a period of 3 or 6 months post termination in the UK, for example, in a competitive business. And it's a really difficult conversations, because we have to then go back in each case to, well, what interest are you trying to protect? Do you need a restriction that spans that geography? And for what length of time? And in each case, there's no one size fits all. So we have to look at what the role is, who the clients are, what's the protection there to do. It can be quite a long conversation to have, and you really do have to sort of focus down on, is it necessary rather than is it desirable? Because everybody wants to, impose restrictions, or most people do, but there's a massive difference between necessity and just something that you would like, isn't there? Comfort,
yeah.
I suppose.
Yeah.
So anyway, the heads up is this. What we tend to do, and what some people do, is they have a blanket restriction, or they'll have got something on the internet, or they'll have copied it from a previous employer. I call them hatchet job contracts, and I'm sure that anybody listening who's worked in HR or in-house legal will know what I mean. A contract that you've carried over from somewhere else, you just cut and pasted because it sounds good, but you've not really given it any thought. I would encourage you at this point to be looking at those types of contracts and just, trying to firm them up a bit. So I'm just going to talk about the different types of restriction now, because it's not just non-competition. So on the next slide, there's lots of different types of restrictions, and this is after the employment has ended. So the first one is non-competition, exactly what it says on the tin: don't go work for a competitor for a period of time. Now, these are historically harder to enforce than the other types of clause, because going back to the first slide, obviously there's got to be a freedom to work for individuals, and if you are going to try and stop somebody working in a field that they may have practiced in or been employed in for many years, then you do have to justify why that needs to be the case. Perhaps more easy to justify are clauses like non-solicitation of clients, and that's exactly what it says on the tin too: actively going and soliciting clients. So, for example, I leave a firm and I approach every single person who I've ever acted for within 3 days of leaving and ask them to move business with me. That would be actively soliciting the person. We used to have then people coming to us, and we still do, saying, well, I haven't solicited those clients, they came to me, or the customers came to me. And the way that that's protected in a contract is through a non-dealing provision, which is also a restriction. So that prevents the argument of, well, they came to me, I didn't actively solicit them. It's a provision that says you cannot deal with them, even if they came to you for a period of time. You've got the non-poaching, and that might be of staff. I normally say that's of employees, so to prevent team moves and pinching other people's, trained staff to go and move somewhere else, and that might be to set up in competition as a breakout group, or it might be team move to another employer or company or a competitive business, so that you can look at restricting those post-termination. And then something that's used really regularly as a contractual term, I've put it under restrictive covenants because in a way it is for the employer to be allowed to place a person who resigns on a period of garden leave. In other words, they're excluded from the premises and they don't work normally, but they remain employed until the end of a notice period. So they're subject to the duty of all their employment terms, and they remain employed, but you sit them at home. I don't know where the garden bit comes from in the UK, because we never get enough good weather to sit in your garden, do you? But it basically means you're sitting them at home, you're benching them, I suppose. And that's a really useful tool in the sense that obviously it takes somebody out of the business. You still do need to pay them, so they remain on full pay and benefits. That's sometimes a drawback for the employer. The employee is sometimes annoyed if there's a period of garden leave that's excessive, if it might damage their ability to carry out the role, or their knowledge base may deteriorate. But I don't really see as many complaints about garden leave as I do about the restraints, and I suspect, without being cynical, that's because you're still being paid if you're on garden leave, whereas in a period of restraint after you've left, you're not paid. And a common complaint from employees is, well, how can they restrict me if they're not paying me? And at the moment in this country, you don't have to pay or give consideration for the restrictions to a degree. What you often find with restrictions as well is that the period of time is often set off against any time spent on garden leave. So in good contracts, well-drafted contracts, what you'll tend to get is a period of 3 or 6 months, let's say, restriction. But if there's a 3 months notice period and you put somebody on garden leave, that's set off. So you're only restricted then for 3 months after the end of the employment to make it fairer. And that all goes to the reasonableness question. Was it reasonable? Did you act reasonably? Rather than sitting them on garden leave for 3 months and then imposing a 6-month restraint, for example. So the other things that I just wanted to mention here was not to forget in your contracts about confidentiality provisions. It's great to have some really robust confidentiality provisions and intellectual property provisions as well. If you're looking at your contracts and they maybe need a review, have a look at all of those things and see if any of them are in and do they actually work. Okay, so I'll move on from that then to the next slide. Okay, so in terms of questions that we get asked a lot, it's what action can I take, basically. Let's take a non-compete clause. So say you work in a business and an employee leaves to go to a competitor and they are restricted in the contract from doing so, and you have a legitimate reason for that and all the boxes are ticked. The general action in relation to restrictions is either for a company to seek an injunction, which means to stop the individual from doing what they are doing and or the competitor from taking them on. Oh, hang on, I've lost my slide there. Alison, your inbox appears to be on the screen. Or to seek damages for any breach of contract. In other words, your financial loss. Now, in terms of injunctive proceedings, these are very expensive, as I mentioned earlier. The last injunction I ran was a relatively straightforward injunction, but the costs were over £60,000. We were successful in obtaining the injunction, but when we went for costs against the individuals, I was for the company. Obviously, they didn't have the money to pay. We did get costs awarded, but it was secured against the homes, and I don't think we'll ever see that money again. So it's a massive outlay in terms of litigation costs, which at the moment, and quite rightly so, I can understand why people would want to avoid. What you generally find then in terms of enforcement is very robust correspondence before any litigation action is taken, and we call that a letter before action, where individuals are contacted and reminded in no uncertain terms of their obligations. Those letters can be very long. They're not particularly nice. If you're an employee, you should seek advice immediately. And if you're an employer, you should be careful and only put forward things that you can legitimately rely upon. The bullying letters without substance are frowned upon by the courts. So moving on from that then to the next slide. There are a couple of cases that we thought might be useful. You've got this Egon Zender Limited case. This was a really interesting one because it was about the wording of a restrictive covenant. And basically, the claimant in that case was a consultant and recruited by the company, Egon Zender. And the company provided sort of executive search services. She was really well known and considered, a really good catch for the company. And she was quickly promoted, and as people are, eventually became global head of financial planning services group. She resigned and said that she was going to a competitor, and there was a restriction, and she was actually going to go to the competitor within a month short of when the restrictions would end. And the wording of the restriction was in dispute in that case, and it's been all the way up to the Supreme Court, which is why I think it's a good example. You should look at the case if you want sort of a detailed overview. But in short, all the different courts looked at the wording of this clause, and the wording of the clause said that she wouldn't, within 6 months of the termination date, directly or indirectly, engage, be concerned, or interested in any business carried on in competition with any business of the company. Now, the key phrase here was or interested in. So when you're looking at your clauses, have a look. What she said was, well, that's far too wide. It's not reasonable. It means I can't even be a shareholder in a business, even if I've no other interest. Yes, Alison?
Okay, I need to pause you there. You've done brilliantly. We've had a little bit of a technological going on in the background situation, and LinkedIn, because the post was still live from the old link that didn't work, blah, blah, blah. There's a couple of people. So we've got a Jane Trower, who I'm going to add to our stream here. Jane, David. Jane, can you hear us?
Hello. No, I'm sorry, I can't.
You can't hear me?
I'm having a few technical problems this morning with this.
You're not alone.
Which is a shame because it's a fantastic subject.
Yeah. So you're here, so that's fine. But you can hear us, can you?
It's very, very low, only very minimally. But never mind.
Okay, well
I'm just reading your brilliant slide. Thank you.
Okay. And then David Jones, I can see David Jones is connected. Ah, there we go, Jane. Hi. David, it says something about you're there, but your device is not connected. So I don't know what's going on with you, David. So this is what happened was, Jane and David and anyone else who's watching, is that we set up the room, the live, and normally it always works, no problem. But for some reason, when we started it, it came up with an error here saying that the LinkedIn link didn't work. So unlike Zoom, where you can just pop out and pop back in, when you stop a broadcast, you can't get back into that same link. So that's left hanging. And then we just thought we would just keep going. So for anyone that's wondering, so apologies, it's not been our usual slick self, but I'm going to let Marie carry on, because she was on a roll there, and I was huffing and puffing in the background.
Sorry.
Off you go. Do you want to go take it from do you want to take it from the top of this slide again, Marie?
I will, yeah. So this case is really interesting because it went all the way to the Supreme Court. And the clause that was in dispute was that the individual couldn't at any period from the period of 6 months from the termination date, directly or indirectly, engage, be concerned or interested in any business carried out by a competitor, in brief. And a lot of the litigation centred around the words or interested in. And what the claimant said was, well, that stops me being a shareholder even in a business, and that's not a legitimate business interest to protect. There were a plethora of other arguments. And basically that was in dispute. So at first instance, they were saying, actually, yes, we think that is too wide. That clause is drafted too widely. Goes to the High Court. The High Court looked at it in the way that I have just described. So the questions it asked itself was, what does the covenant mean when it's properly construed? Has the employer shown that it's got a legitimate business interest requiring protection? And is the restriction no wider than reasonably necessary to protect those interests? Okay. In the end, what happened in the Supreme Court with this and the words or interested in is that they used what's called the blue pencil test. So some people might have heard of that, where if in certain circumstances a clause can be amended without adding to it or changing its meaning in any way, by simply striking a line through the words that are causing confusion or offence, then they can do that. And then if the rest of the clause still reads well and makes sense, that's a way to resolve the issue. And so what they did was they just struck out, in this case, or interested in, using this blue pencil test. And it still made sense. But there was a word of warning in this case about what the Supreme described as legal litter. and costs implications if clauses are drafted badly, because it shouldn't be for the employee to litigate to clear up badly drafted contractual provisions and to pay for that privilege. So I suspect, having read the judgment, and please do read it if you're interested in this area, they might have been a bit fed up that, you know, it went as far as it did, and the cost and time involved for all parties will have been ridiculous, absolutely ridiculous. In that
Oh dear, and now Marie has gone, so I'm hoping she'll be able to click back into the link so we can continue with that. Jane, your video seems to have gone. So we're all frightfully unstable.
Yes, unfortunately the technology's not working that well, which it's such a great subject. It's so relevant.
Oh yes, Marie's back. Okay, here we are.
Yeah, sorry, it just cut me off completely then. I think we've got a technology problem today, haven't we?
Yeah.
Do you want me to carry on, Alison?
Yes, definitely, yeah.
Yep, okay. So we've got another case here as well. If you go on to the next slide for me, please. We've already said that that's the type of restrictions that we need. The next case I was going to talk about is a case called Quilter, Private Client Advisors and Falconer. In this case, what the court looked at was the contract in I suppose, its entirety, and there was a probationary period in this contract of 6 months, but a restriction for, I think, 9. And during the probationary period, employment could be terminated within 2 weeks. So there was a real mismatch between, you know, why you would need a lengthy restriction if the notice period was so short. Lots of different arguments about why that would be an unlawful restraint of trade. And in fact, it was found to be unlawful at the time. And they also took into account, interestingly, that the head of the company only had a 6-month non-compete. So they looked at the status of the individuals as well, which is obviously relevant. So as a whole, I suppose what we're saying is review from top to bottom and don't try this one-size-fits-all job, but make sure that you're consistent in your restrictions and you can legitimise what you're trying to protect, because that was also an issue in this case. The company had difficulties identifying the legitimate business interest. Of interest further in that case is that in terms of restraints and reasonableness, going forward element of that, you know, can you restrict for 3, 6, 9 months, for example, which are the most typical ones? But there's also a period in retrospect. So normally in these clauses it will say you can't, for a period of 3 months after you leave, deal with anybody who for the period of 12 months before you left you had personal and material dealings. And in this case there was an 18-month backstop. Well, she was actually only there 6 months, so it was completely disproportionate. And again, as I say, they couldn't articulate what the legitimate business interest was in that case, so they weren't successful. So with that in mind, you've got the geography, breadth of activities restricted as well. So do you actually need all of the restrictions, or is it just the solicitation and dealing with clients, for example? When you're drafting the restrictions, think immediately how you can justify the restrictions. And if you can't, then think again, is my advice. Consider separate covenants for different types and levels in your organisation. Do you need to actually restrict everybody? If you do, identify the legitimate interest in each case. Think about notice periods and garden leave. And rather than seeking to prevent somebody from working and competition, think about what's relevant in your business. So that's probably your clients, customers, suppliers. Also, do you need to prevent somebody from working with clients, customers, and suppliers? You know, is it all three? Is it just identified competitors? That we're seeing a lot more of that recently, where there will be identified competitors in contracts who individuals are prevented from working for post-termination, and that's easier to look at as reasonable, I think, in certain circumstances. So think about that. Those are all my top tips. Moving on then. In terms of disclosure of other offers, this is something that you often see in contracts of employment. So in other words, if an individual gets an offer to move or a new job offer whilst employed, there's a contractual obligation to disclose it. We don't seem to get many inquiries about that. In itself, they tend to be linked with moving and general post-termination restrictions, if anything. In terms of team moves, there are also clauses you can insert to seek to restrict people from joining companies or moving to companies where senior employees have recently either founded a new company or have moved to a new team there for a period. So you might want to think cleverly about that. And there are there's a separate wording that we can put in contracts to stop and to deter people from team moves, although again, it's got to be legitimate interest and reasonable in the circumstances. Moving on then to the next slide.
Delighted to say that David has joined us on the call as well, and I am in contact with him for a private chat, and he says thank you so much for doing it, and I can see we've got a few more viewers as well, so we're battling on, we're doing well, Marie. It's definitely been worth the time, and
I'm still doing it.
We're just not going to be beaten today.
I'm not giving up.
We're nearly there. David doesn't have any questions. Jane was up on the screen there, but Jane, your video came off. There is a private chat there, Jane, so I can pop you back on. But if you could put your video back on, that would be great, so we could join you to the screen again. But yeah, I mean, so. What do you see the future really, Marie? I mean, I think things have probably changed quite a lot in the last 3 months. Would that be your view on this topic?
Yeah, absolutely. And there has been a consultation about restrictions, which is why it's so relevant at the moment. So there's been a consultation, I think it finished in February, and there are lots of proposals for the future. So, for example, at the moment, and well, in Germany, for example, there is an initiative, or there's they tend to pay or make a payment for post-termination restrictions, the duration of the restrictions. So I'm just trying to find out how much it is actually. I've forgotten about that. The 50%, that's it. So basically, if they restrict post-termination, employers are asked to pay 50% of the previous overall remuneration during that period of restriction, which obviously puts employers off from restricting people when they don't need to, but it also compensates employees when they are restricted if they're not able to work in their chosen field. And that's something that the UK is looking at as part of the consultation, between 60 to 100% of earnings if you want to restrict. So that could be a huge change. It's a bit nuclear actually. One of the more nuclear proposals is that they just ban non-competition clauses altogether. Right. And that is nuclear, so I don't know about that.
I mean, you say consultation, that's at a governmental level, is it?
It is, yes, and it's closed now. So there's been a lot of input. The Employment Lawyers Association, for example, had a lot of input with that. I'm a director there. The other things that they have actually thought about was a sort of maximum term for non-competes, and should there be an overall maximum? What should that be? I mean, clearly they do want to change this. And we do live in an economy where we are encouraged to be creative, competitive, to start new businesses. So I do think that there will be changes, whether it's a ban, whether it's payment terms, who knows, whether it's a longer minimum notice period. We don't know yet, but it's a watch this space. It's a watch this space job. I mean, in Germany, they have a ban on 2 years. The cutoff is 2 years. It's a maximum of 2 years. So we're waiting to find out. Yeah, the consultation closed in February 2021, 26th of February.
Yeah.
So have a look at your contracts now.
Yeah, absolutely. Jane's asked us, will we be able to see the video afterwards? Yes, you will, in all its glory. Comings and goings. I tell you, it's like BBC breakfast here, isn't it? Not. But listen, Marie, thank you so much. That was excellent. And that was just a little bit of internal office drama here. So thank you so much.
Well, we've had fun anyway. We've had fun, Alison.
My husband's there.
He's wrecking the joint. He's wrecking the joint. You've had it.
This is people vision at its best. Oh my God. Right, I think we better draw to a close. Thanks everyone. And obviously we are
Thank you.
professional. This is not our best time. Bye.
Bye.